Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
And welcome back, y'all. Welcome back. Have a seat, grab your drinks, grab your popcorn or wherever you would like to eat. And let's get into the newly updated court update. Okay. So we're here to have a conversation about Daystar Peterson, also known as Tory Lanez, his filing for a motion for protective order. Now, literally within an hour ago, MeganPete's opposition to Daystar Peterson's motion for protective order court document has dropped, and that's what we will be getting into today. Now, before I get started, let me make sure y'all see my copyright disclaimer under Section 107 scrolling at the bottom of your screen there. This is fair use. I am simply saying that I am not a paralegal. I am not an attorney, and I am also not a judge. I am simply saying that, hey, I know how to read, and I also have common sense. And also, for any reason that you will want to donate, my Cash App is right there as well. $ Document Tingz. And yeah, well, let's get into it. This is the actual court document that was just dropped, and we're going to get into it. All right. So this is just a little bit of table of authorities, table of contents, etc., etc. We're going to scroll down and get to reading. Okay. So here go the introduction. This proceeding arises as a direct result of Mr. Peterson's deliberate obstruction of 2 deposition attempts, reflecting a calculated contempt for the judicial process in open defiance of 2 federal court orders. The underlying action, Pete versus Cooper, pending before the Honorable Cecilia M. Altanaga in the Southern District of Florida, was filed on October the 29th of 2024. The case is about the extensive and persistent defamation by defendant Milagro Cooper of plaintiff MeganPete, also known as Megan the Stallion, at the behests in command of Daystar Peterson, also known as Tory Lanez, during and after his conviction for shooting MeganPete or Miss Pete in 2020. Defendant Cooper, a social media personality, has used her social media accounts to spread defamatory statements, deep fake corn videos, and outright lies about Mrs. Pete as part of a coordinated campaign with Mr. Peterson. Trial in the Florida action is currently set for November the 17th of 2025, less than 6 weeks away. So any further delay in Mr. Peterson's deposition will unduly prejudice Miss Pete, which is Mr. Peterson's intent. Mr. Peterson has repeatedly expressed his intent to defy the court's deposition process since initially being served in March of 2025. He issued a press release through his counsel at Unite the People, stating that he would refuse to testify and then evaded testimony both at his original deposition on April the 9th of 2025 and his court-ordered continued deposition on September the 15th of 2025. This motion is Mr. Peterson's latest attempt to evade providing testimony via a belated attempt to acquire a protective order. Mr. Peterson, who is currently serving a 10-year prison sentence in California State Prison for shooting Miss Pete, is a key witness in the Florida action, as he has for years tried to silence Miss Pete through repeated harassment and paid cyber stalking. After a California court ordered him to not talk about Mrs. Pete, he began using paid surrogates, including defendant Cooper, someone with deep ties to Mr. Peterson and the Peterson family. Defendant Cooper has acted at Mr. Peterson's direction, helping him circumvent multiple protective and gag orders that bar him from speaking publicly or posting about these matters. She has insinuated that she is on Mr. Peterson's payroll and has publicly acknowledged her friendship with Mr. Peterson and his father. The malicious content she posted that give rise to the underlying complaint was done for the benefit of Mr. Peterson. The Florida action seeks to hold defendant Cooper accountable for defaming and harassing Ms. Pete, something done in part because of payments she received from Mr. Peterson's network. Mr. Peterson's motion must be denied, as this belated motion was brought only because his other attempts to evade testimony and ignore court orders have failed. First, Mr. Peterson's motion is untimely pursuant to Federal Rule of Civil Procedure 45 and should be denied on that basis alone. Mr. Peterson's arguments must be deemed waived because he had multiple opportunities to raise all of the alleged issues set forth in the present as the present motion from March 10th of 2025, the date he was served with the present subpoena to August the 1st of 2025, when Judge Altanaga issued an order sanctioning him for his conduct at his initial deposition and ordering a continued deposition under court supervision. Second, Mr. Peterson has not met his burden to prove good cause warrants a protective order. He offers only broad objections with no support and authority. Third, he cannot show undue burden exists to quash the subpoena. Ms. Pete, on the other hand, explains herein why Mr. Peterson's deposition testimony is necessary to complete the record in Florida action set for trial next month. Finally, Mr. Peterson's arguments that this court should alternatively order a written deposition or shift fees to Ms. Pete are meritless. Okay, so let's get into the background. The complaint in the Florida action alleges that defendant Milagro Cooper engaged in defamation, promotion of an altered sexual depiction, intentional infliction of emotional distress, and cyber stalking against Miss MeganPete, aka Megan the Stallion, or Miss Pete. And then look at exhibit, which is docket 37. Now, docket 37, this is the amended complaint. Now, if you want to look at the amended complaint, look at the top left-hand corner. As y'all can see, that is my QR code. That will take you directly to my X, formerly known as Twitter page, and you can get into the actual court document there, the amended complaint court document. I also have a plethora of other cases that I'm also covering and keeping an eye out on. Again, top left-hand corner, QR code. You can go to the page and you can pull this up. Defendant Cooper is alleged to have committed these acts by coordinating with Mr. Peterson to spread lies and spew derogatory narratives about Ms. Pete. Evidence to date has shown that defendant Cooper has deep ties to Mr. Peterson and frequent communications with Mr. Peterson's family regarding Ms. Pete prior to publishing harassing content about her. As the complaint alleges, defendant Cooper conspired with Mr. Peterson after he was charged with shooting Ms. Pete to spread lies about Ms. Pete. Payment records revealed that Mr. Peterson's father, a close friend of defendant Cooper's, frequently made payments to defendant Cooper, and defendant Cooper herself has implied she was on Mr. Peterson's payroll. And it says, look at Exhibit B, Zelle records. She has countlessly posted malicious content demeaning Ms. Pete in support of Mr. Peterson. And then again, look at Exhibit A, page 35 and 36. That's referring back to the actual amended complaint. Now, what I'm going to do right now is I am going to show you Exhibit B, which is the example of what they're saying. All right, so let's get into Exhibit B. Now, Exhibit B is just showing you the actual alleged payments totaling $3,000. So y'all can see right there, token list. It shows milagograms@gmail.com. All right. It was over a span of maybe 4 years, roughly 4 years. This was 10/8/2020 to 12/16/2024. And these are the alleged payments totaling $3,000. Okay, as y'all can see here. So, alleged payments, okay? And this is from the subpoena search. This was done December the 16th of 2024 through Zelle. All right, so let's get back to what we were reading. I just wanted to show y'all that just really quickly. So we're going to get back to what we was reading. Y'all give me 1 second. All right, and then boom. Let me let that load up real quick. Maybe y'all see it on y'all screen, but I do not see it as of yet. It's still showing that it's scrolling. Okay, hold on, y'all. Okay, there we go. All right, so we're going to start right here. Discovery has been underway in the Florida action since January of 2025. Plaintiffs sought to take Mr. Peterson's deposition and get documents in support of her allegations that defendant Cooper acted in coordination with Mr. Peterson. On February the 21st of 2025, counsel for defendant Cooper, including Michael Hayden from United People, also counsel for Mr. Peterson, agreed that they would not oppose a motion to take Mr. Peterson's deposition pursuant to Federal Rule of Civil Procedure 30A2B, which requires court approval to depose a prisoner in California. On February the 24th of 2025, Ms. Pete filed a judge, well, Mrs. Pete filed and Judge Altanaga granted an unopposed motion under Rule 30AB to take the deposition of Mr. Peterson. The order permitted that plaintiff may take the oral deposition of Daystar Peterson. And then you can refer back to Exhibit C, Docket 42, Rule 30 order. All right. On March the 10th of 2025, Mr. Peterson was properly served by the litigation coordinator at the prison where he is incarcerated. A subpoena issued by the Southern District of Florida, Exhibit D, subpoena, Exhibit E, affidavit of service. 2 days before the initial deposition was scheduled, Unite the People's CEO issued a press release ahead of Mr. Peterson's deposition stating, "Good luck trying to get Mr. Peterson to testify to anything. It's just not what he does." See Exhibit F. Go and you can refer back to Docket 65, Unite the People's Inc. press release on April the 7th of 2025. The original deposition took place on April the 9th of 2025. At his deposition, Mr. Hayden appeared on behalf of Mr. Peterson's. "You are being represented here today by Mr. Hayden from Unite the People, right?" To which Mr. Peterson responded, "Yes." You can refer back to Exhibit G, which will be his actual deposition, well, short deposition. Mr. Peterson's behavior at the deposition was obstructive, exactly as he had intended. In the 44 minutes on the record, Mr. Peterson's feigned ignorance regarding the defamation of basic words such as discuss and approve, and y'all can see they're just quoting the time frames, harassed Miss Pete's counsel about her appearance, again, time frames when he did that, interrupted questioning to discuss his answer with Mr. Hayden, again, time frames, and pretended that the video equipment was not working despite prison staff confirming it was functioning properly. Again, you can see when he did that there, time frames. Due to his obstructive conduct, Ms. Pete filed a motion seeking an order to show cause for violating Judge Altanaga's Rule 30A2B, order permitting Peterson's deposition. Mr. Hayden did not oppose the motion and did not raise any objections or concerns about Mr. Peterson sitting for deposition. You can refer to Exhibit H, which is Docket 65, and it's showing that it's an email from Unite the People. All right, so on April the 17th of 2025, Judge Altanaga issued an order to show cause as to why Mr. Peterson should not be held in contempt of court for violating the court's order authorizing his deposition. Go back to Exhibit I, and that is on Docket 66, order to show cause. Ms. Pete properly served Mr. Peterson with that order on April the 17th of 2025. That's on Exhibit J. Okay, service of order. Again, I have all of these. What they're referencing here is on my X page, top left-hand corner. Okay, let's continue. Despite proper service and ample time for response, the deadline for Mr. Peterson to respond to that order came and went. Indeed, an additional 90 days passed without Mr. Peterson's counsel responding or raising any objection to the order to show cause. You can refer back to Exhibit K, which is Docket 103, notice of 90 days expiring, on August the 1st of 2025. Mr. Peterson's failure to respond to the order to show cause resulted in Judge Altanaga issuing an order sanctioning him for his conduct at the initial deposition and requiring him to sit for another deposition under the supervision of United States Magistrate Judge Lisette M. Reed. You can refer back to Exhibit L, which is on docket 104, order granting sanctions. Magistrate Judge Reed and the parties coordinated to have the continued deposition on September the 15th of 2025. On September the 9th of 2025, Ms. Pete's counsel served a notice of deposition directly on Mr. Peterson in prison. Exhibit M, notice of service. On September the 15th of 2025, Mr. Peterson showed up to the deposition. Mr. Peterson's new, well, let me rewind back. Mr. Peterson showed up to the deposition. Mr. Peterson's new counsel, Ms. Morgan, who herself continued to work at Unite the People until earlier this year, claimed at the deposition that the Southern District of Florida had no subject matter jurisdiction or personal jurisdiction, and that she did not have time to prepare for the deposition. Refer back to Exhibit N. We're going to have to go get that. Okay, Peterson Volume 2, and it shows the time frame there. Mr. Peterson also claimed that he was not previously represented despite his prior testimony that Mr. Hayton with Unite the People represented him in April. See Exhibit G. Instead of providing substantive testimony, Mr. Peterson asked Magistrate Judge Reed what the consequence would be if he left the deposition. When Judge Reed stated that the sanction for not testifying will be, at the very least, the attorney fees and costs for all the attorneys who had appeared today, Mr. Peterson replied, easy, referred to Exhibit N. Oh, we're going to have to get into these exhibits. When it says when other potential consequences, including additional time for incarcerations, were mentioned, Mr. Peterson responded, hey, listen, I've got jail for 10 years right now. You can do whatever you like to do. And mockingly offered, I'll pay your flight. Don't worry. Neither Miss Morgan nor Mr. Peterson raised any objection to the taking of his deposition on the grounds that his Fifth Amendment rights pending appeal of his criminal case would be violated by such a deposition, nor did they seek the relief they now ask for. Mr. Peterson's 11th hour attempt to raise these issues demonstrates his blank disregard for the judicial process and his willful strategy to delay and obstruct these proceedings as trial approaches. In sum, counsel for Ms. Pete has attempted the same deposition for Mr. Peterson twice now over the last 6 months in compliance with Federal Rules of Civil Procedure 30 and 45 and 2 federal court orders from Judge Altanaga in the Southern District of Florida. Mr. Peterson, in turn, has followed through on his stated intentions to evade providing testimony necessary for Ms. Pete to put forth her case, including by filing this latest meritless motion. And then that is the legal standard, which is a bunch of quotes from different court cases, which we're going to scroll on through. We're going to go right here to argument. This motion should be denied as untimely. As a threshold issue, this motion is untimely. That is the sole basis needed to warrant, 1, a denial of this motion, and 2, an order requiring Mr. Peterson to comply with the subpoena and sit for his court-ordered continued deposition under the supervision of Magistrate Judge Reed, pursuant to Judge Altanaga's August the 1st of 2025 order. Contrary to the assertions in Mr. Peterson's present motion, he was timely served with a subpoena issued by the Southern District of Florida, the court in which the action originated. And then you can refer back to that particular Fed or Civ. All right, so let's continue here. Some courts have found that this timing requirement can be extended to the date of compliance on the subpoena, and that's just going over a different one. Then they're talking about motions of quash, which is quoting a different court case. Okay, so we're going to start right here. Are required to be filed in a timely fashion, with which courts have read to mean before the compliance date designated in the subpoena. A non-party's failure to timely make objections to a Rule 45 subpoena, duces tecum, generally requires the court to find that any objections have been waived. Failure to explain why a motion to quash is untimely results in denial of that motion. And then there's another quote. It says Mr. Peterson was initially served with a subpoena on March the 10th of 2025. Refer back to Exhibit C. Pursuant to Rule 45, Mr. Peterson had until March the 24th of 2025 to object to the subpoena served upon him. It says even under the more lenient compliance date requirements for timeless, Mr. Peterson had until April the 9th of 2025, the date of compliance listed on the subpoena, to bring any objections. He did not. Instead, Mr. Peterson complied with the subpoena by appearing at his deposition on April the 9th. The record demonstrates that he was represented by counsel, Mr. Hayden, for the deposition and answered questions at the deposition. He never objected on the basis of jurisdiction to his appearance in Volume 1 of his deposition. The motion for protective order and to quash the subpoena must be denied as untimely under the Federal Rules of Civil Procedure and Ninth Circuit case law. Even if the court found that this motion is timely, all of Mr. Peterson's arguments must be considered waived. Mr. Peterson should have brought these arguments in the present motion when he was issued an order to show cause by Judge Altanaga in 2025 of April. He could not now, 6 months after he was served with the subpoena and 5 months after compliance was required, retroactively benefit from an untimely motion to quash. And it says B, Mr. Peterson's arguments cannot meet his burden of persuasion. Although Mr. Peterson's arguments should be deemed waived for the reasons set forth above, they nonetheless fail on the merits. Mr. Peterson has not established good cause to grant a protective order. Motions for protective orders require a showing of good cause under Federal Rule of Civil Procedure 26C and broad allegations of harm unsubstantiated by specific examples or articulated reasoning do not satisfy the Rule 26C. And in this, we're quoting another case. Courts may consider the following factors when determining whether good cause exists to issue a protective order. Is the information being sought for a legitimate purpose? That's number one. Number two, will the disclosure violate any privacy interest? And then number three, will disclosure cause a party embarrassment? And then number four, whether disclosure is important to public health and safety? And then number five, will sharing of the information among litigants promote fairness and efficiency in the litigation? And then number six, whether the party seeking the protective order is a public entity or official. And number seven, whether the case involves issues of public importance. And that's a quote case from another case, y'all. Mr. Peterson's motion is a string of broad allegations that do not establish good cause to warrant a protective order or quashing of the subpoena. Mr. Peterson appears to argue he is entitled to quash the deposition under the Fifth Amendment and that a protective order should be issued given his pending criminal appeal of his conviction for shooting Ms. Pete. However, Mr. Peterson's request for additional safeguards pending the appeal of his criminal case are misguided and unwarranted. A deponent cannot assert the Fifth Amendment to avoid a deposition altogether. The proper procedure is for the deponent to attend the deposition, be sworn on the oath, and respond to those questions he can answer without running a risk of self-incrimination. Okay, we're going to scroll on. A witness is not exonerated from answering merely because he declares that that in so doing, he would incriminate himself. His say-so does not itself establish the hazard of incrimination. It is for the court to say whether his silence is justified and to require him to answer if it clearly appears to the court that he is mistaken. In both the original and continued deposition, Mr. Peterson attended and never raised a Fifth Amendment privilege issue to avoid sitting for his deposition. Mr. Peterson cites to one case, which is Keating versus Office of Thrift Supervision, to establish that this court should stay his deposition in the Florida action. But this case supports the proposition that Mr. Peterson indeed should testify at deposition. In Keating, a party to a civil proceeding, Charles Keating, attempted to stay the civil proceeding due to parallel criminal proceedings related to the same conduct. The Ninth Circuit found Keating's arguments unpersuasive, where the civil claims were unrelated to the federal charges. And then y'all can see that's going back to ID at 325. The Ninth Circuit further found that Keating's Fifth Amendment rights were not violated when Keating appeared in the civil hearing, waived his rights, and asserted the privilege. Indeed, the court concluded that, and then that's a little quote from that. Y'all can see there. We're going to continue on. You can pause your screen. You can read that, but we're going to continue on. Hereto, it is permissible to conduct a civil deposition at the same time Mr. Peterson's pending appellate decision. Moreover, the deposition questions regarding Mr. Peterson's relationship with defendant Cooper do not implicate Mr. Peterson's Fifth Amendment right. Evidence or defendant's Cooper relationship with the Peterson's family do not bear on his criminal proceeding and appeal. They are, however, directly relevant to Mrs. Pete's claims against defendant Cooper. Mr. Peterson should be compelled to respond to questions regarding his campaign to harass and defame Ms. Pete with defendant Cooper. For any questions that could incriminate him, Mr. Peterson can invoke his Fifth Amendment privilege on a question-by-question basis, the very approach Keating endorses. See also Hansen, and y'all can see that's the quote there. His rights will be protected at his continued deposition, as it will be conducted under the supervision of Judge Reed, who can determine whether his silence is justified. Mr. Peterson's testimony and accompanying documents are being sought for a legitimate purpose: to prove the claims in the complaint that defendant Cooper was in communications with Mr. Peterson and furthered her misconduct pursuant to his request. Ms. Pete cannot obtain information about defendant Cooper and Mr. Peterson's discussions from anyone else, especially in light of the fact that Ms. Cooper has intentionally deleted communications from her devices and spoliated evidence. Moreover, the information sought is not protected by any attorney-client privilege. It pertains to conversations between defendant Cooper and Mr. Peterson. Mr. Peterson possesses unique firsthand knowledge of his coordination with defendant Cooper, and his testimony is relevant to establish their coordinated defamatory campaign. Mr. Peterson has failed to demonstrate good cause warrants a protective order over him or any of the testimony he might provide. The court should find that the Ninth Circuit reasoning in Keating applies and deny the request to enter a protective order, as any further delay would generally prejudice Ms. Pete. Mr. Peterson has also failed to establish undue burden to quash the subpoena. All right, so let's get into this. There's a lot of quotes from different cases. The moving party bears the burden of establishing that a subpoena is unduly burdensome. Whether a subpoena is unduly burdensome depends on the facts of each specific case. Courts also weigh the burden to the subpoena party against the value of the information to the serving party. Generally, this requires consideration of relevance, the need of the party for the documents, the breadth of the document request, the time period covered by it, the particularly with each the documents are described and the burden imposed. Okay, that's another quote. Let's go right here. Courts usually only quash subpoenas of non-party witnesses where the information sought is not relevant, is immaterial to the allegations, or could easily be obtained from a party to the litigation. And we're just going to scroll on. Y'all see that quote there? Okay, so we're on page 18. Mr. Peterson has knowledge relevant to the critical issues of this case, and thus his subpoena should not be quashed. Starting in 2020 and continuing to the present, defendant Cooper has used her social media accounts to spread defamatory statements, deepfake porn videos, and outright lies about Ms. Pete at the behest of command of Mr. Peterson. As the complaint alleges, defendant Cooper conspired with Mr. Peterson, wherein Mr. Peterson would arrange for payment so that defendant Cooper would spread lies about Mrs. Pete. In fact, defendant Cooper herself implied that she was on Mr. Peterson's payroll. This material evidence goes directly towards proving defendant Cooper acted with malice and engaged in intentional infliction of emotional distress by pairing up with the man who assaulted Mrs. Pete to spread lies about her and harass her. Given the importance of Mr. Peterson's deposition to her case, Ms. Pete has consistently pressed for his deposition and worked to alleviate any burdens on the witness. The deposition was held over Zoom and in person at the correctional facility where Mr. Peterson is confined. After the second deposition was adjourned, counsel for Mrs. Pete reached out to Ms. Morgan to meet and confer to resolve this issue outside of court in compliance with Standing Order and Central District of California Local Rule 37. Instead, Ms. Morgan filed this motion without conferring with Ms. Pete counsel. See Exhibit O. This court should deny Mr. Peterson's motion and require him to participate in good faith in a deposition supervised by Magistrate Judge Reed, with trial proceeding next month. This court should require him to complete the court order deposition that he has twice appeared but refused to testify in. And then C, Mr. Peterson, getting tongue-tied there. Mr. Peterson's alternative request for relief are meritless and should be denied. Mr. Peterson asks this court to grant a protective order, move to quash the subpoena, or grant his request for two alternative avenues. One, limit any deposition to written questions under Rule 31. And two, shift costs to Ms. Pete motion at 6. Each of these alternative requests, in addition to being untimely or meritless. First, a written deposition under Rule 31 should only be granted if consistent with Rule 26B1 and 2, Fed RCIV P31, Rule 26B1 and 2, asks whether the deposition is proportional to the needs of the case. And Mrs. Pete has established above why Mr. Peterson's deposition testimony is proportional to the needs of Florida action. Mr. Peterson has already stated and demonstrated he will not answer questions when asked under oath at a live deposition. Thus, any attempt to get him to answer written questions would be futile. Fail to provide evidence and will only further delay these proceedings. As a result, Ms. Pete would be greatly disadvantaged by a deposition of Mr. Peterson's via written interrogatories. Okay, it says right here, that's a quote. It says, instead, the court should order a continued live deposition under supervision of Magistrate Judge Reed, as already ordered by Judge Altanaga. Second, Mr. Peterson does not meet his burden of proof to prove that he has suffered significant loss in association with this deposition to justify his request to shift costs to Ms. Pete. The non-party seeking to shift costs also must demonstrate that its costs are reasonable and resulted from compliance with the subpoena. And then that's a quote right there. It says, Mr. Peterson has provided no evidence that he has borne any costs associated for appearing for two depositions while confined in prison. In fact, it is Ms. Pete who bore the cost to depose Mr. Peterson, twice arranging for a court reporter and videographer. Any costs associated with Mr. Peterson's repeated depositions are his alone to bear, as demonstrated by Judge Altanaga's order, ordering him to pay costs for his contempt at the initial deposition. Conclusion, for the reasons set forth above, Mrs. Pete requests that the court deny Mr. Peterson's motion so that Mr. Peterson can comply with the properly issued subpoena and subsequent court orders. And that is the actual court document. When it comes down to what is going on in this particular case, I mean, this is something that myself, amongst other people, have stated from the beginning. At times like this, we have to learn how to shut the F up.
Say that shit for the little damn birds. Why don't you just go shut the fuck up?
Shut the F up. We got to learn how to do that, y'all. A lot of times our mouths get us in trouble. It does. Now, we've all done it. We've all done it. But in situations, we got to learn how to just hush. Just hush. This wouldn't be happening had he not made that, well, alleged, because that's what it is. We don't know what happened. There was an alleged conversation between him and Unite the People, which prompted them to make that post before his actual deposition. And now we're in this predicament that we're having right now. Okay. Now, that conducts this video, y'all. Now, if you like what you see here, hit the like button. It's free. Hit the subscribe button. It's free. Hit the share button. It is also free. I appreciate y'all for getting me over 500 subscribers. I am on the road to getting 1,000, but it does not happen if I don't have the support from you guys. And I appreciate all of you. Okay. And before we get out of here, let's end with the song, y'all. We got to learn how to shut the F up, y'all. And with that, I'll holler at y'all.
A little silence never hurt nobody. Take a breath. And shut the fuck up.